All right, well, welcome everybody. It's about that time. We'll go ahead and kick the meeting off. I'll keep an eye on my mute button and video and make sure that's not turned off for any reason by our president, Chad King. But happy Cinco de Mayo, and I hope everybody has some type of fun plans coming up. But welcome to our May 5th Rotary meeting. It's great to see all of our Rotarians on today, and we have an exciting program as well. So we'll just jump right in, and we'll go ahead and have Joe kick off our song and pledge, and take it away, Joe.
America, America, God shed His grace on thee. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesties above the fruited plain. America, America, God shed His grace on thee, and crowned thy good with brotherhood from sea to shining sea. Oh, beautiful for heroes proved in liberating strife, who more than self their country loved, and the mercy more than life. America, America, may God thy gold refine till all success be nobleness, and every gain
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right, well, thank you very much. And before we jump into our invocation, just a couple quick updates for any of our visitors today. If you haven't entered in your name on the chat, I've got a list already going. Please do. If you're a visiting Rotarian, click on the middle of your bottom of the screen, and I put that on there so we can welcome you today and recognize you with the rest of our group. So with that, if Eric Spivey is ready, I'd like to turn it over to Eric for invocation. Eric, take it away.
Let's pray together. Lord, in these uncertain days that are impacting our work, our family, our community, our nation, and our world, teach us to work with love, knowing that work is love made visible. Teach us, O Lord, to weave kindness into our words and actions, for all of us, O Lord, need a little bit of grace each day. Help us to build houses of peace in which our families and our community may find themselves at rest, even with the uncertainty around us. And Lord, may we sow seeds of the goodwill of Rotary, of service above self, and that into all of our actions and deeds and words each and every day. We pray in your name. Amen.
Amen.
Amen. Thank you, Eric. Okay, we'll do a quick introduction of our guests that we have today. So if I miss anybody, maybe Wesley, you can jump in there as well. But I'd like to welcome some guests that we have. Lakeisha King, Cole Barnett, Mark Damon, Jamie Wilson, and Bill Dorman. If you'd like to say anything, now is the time to do it, or forever hold your peace. Okay, do we have any visiting Rotarians today? All right. Well, welcome everybody today. It's nice to have some visitors and with our program today, and so thank you and welcome for being here. A couple quick announcements. I'll kick off the first announcement, I think, for our Fun and Fellowship that's coming up tomorrow. That's going to be a Zoom Fun and Fellowship happy hour. For some of you that are working from home, like President King, you can be on there right at 4:30, but it does kick off at 4:30. And so we are having a Rotary Zoom happy hour social. Bring your soda, bring your water, bring your wine, bring your beer, whatever floats your boat. So this will be our first kind of social on Zoom, so we're looking forward to that tomorrow. And you should have an email after our meeting. We'll send out the link so you can click right on it for tomorrow at 4:30. So looking forward to having everyone join. Our second announcement today, Janice Legler has an announcement for our Rotary Youth Exchange. So Janice, go right ahead.
Youth Exchange, we saw Maya's presentation from Sweden in a recent meeting, and she will return in June. The other 3 students are back safely. Miguel went home when they closed the borders to Spain March 22nd, and Pink has gone back in April. In March, we got word that the volunteer officers in the district voted to suspend our program for the next school year. So what that means is the students who've been working to go abroad will not be going abroad, and that's a great disappointment to them. So other than doing some recruiting for the following year, this fall, our program is suspended for the coming academic year. I want to shout out to Bill, who's done a fantastic job in counseling Miguel. He's supported him in the Miguel and his soccer team. They've gone on kayak rides or boating, and also on long bike trips. And he will serve in the next year as well. Now, I will be leaving shortly and assuming the responsibilities of the Rotary Youth Exchange Officer will be Deborah Newell. And Deborah has been fully vetted, and she's completed all of the required tests and background checks. And so she's excited about taking over the position of exchange officer. And she's already chaperoned our inbounds for 4 days at Disney, and she's also chaperoned at an orientation at Lake Wells. So she's just really jumped in feet first, and we think it'll be a wonderful year, and Bill and Deborah make a fantastic team. So I know you'll give them all your support in the coming year. That's it.
Well, Janice, thank you for that update, and you and your entire team, you do a great job. That is really time consuming, and you make it a really memorable experience for our Rotary Youth Exchange. So thank you to you and your team, and in Pizza Bill with all of his fun hiking and kayaking trips with the safety rules that go along to keep everybody having fun. So thank you for that update, Janice. We really appreciate what you and your team does to make that special and make that happen. So thank you. And with that, I'm going to go ahead and turn it over to President Chad.
Hey everyone, I'll be brief. I just have one announcement today. It's the same that you heard last week. Elder Care of Alachua County has funding for meals, but they don't have transportation for delivering the meals. I've had a few of you reach out to me, about 3 or so. If anyone else is interested in helping deliver meals for Elder Care of Alachua County, please email me, or you can put something in the chat box during this meeting and I'll be happy to get you the information on that. And now, Richard, if you would introduce today's speaker, please.
Yeah, I'm happy to. And before I do the introduction, Wes just wanted me to remind everybody that if you get a chance to do any of the makeups by going to YouTube and looking at some of our previous meetings, please email us at info@rotarygainesville.org so that we can be sure that we get that into the DAC-DB makeup side. Wes handles all that and does a terrific job of keeping track of all that. With that, our speaker today is Paul Donnelly. Paul's been a friend for many years here in Gainesville. And I just learned today that he's also quite a musician. So he shares that with a number of members of our club. Paul is a partner in Donnelly & Gross, a firm that's dedicated to employment-related matters. He's one of the few attorneys ever selected as a fellow in the College of Labor and Employment Lawyers. And Paul and his firm are ranked as a Tier 1 best law firm in the United States by US News and World Reports. The firm works with clients all over Florida and has offices in Gainesville and in Fort Myers. And the topic today is going to be really interesting because as all of us get ready to go back as customers into business establishments, retail establishments, professional establishments, service establishments, what are we going to be expecting? And if you are a business person, how in the world do you prepare for this? What are you required to do? And what might be a good idea for you to do? These are some of the topics that Paul's going to cover today, and he's been gracious enough to give us plenty of time at the end for questions. So we'll have plenty of time for that. And with that, thank you and welcome to the meeting, Paul.
Thank you, Richard. We're going to go through a PowerPoint today, and I'm going to try to go relatively fast, not too fast, but relatively fast through it so that we can have plenty of time for questions and discussion towards the end. Richard's going to make this PowerPoint available. So, you'll be able to get it, and there's hyperlinks in there. There's going to be a lot of citations we have to the various laws, regulations, emergency orders, and that kind of thing. And you'll be able to just hopefully just click on those links in that PowerPoint. The governor, as probably most know, the governor issued a new order on Thursday. Alachua County followed up with its own emergency order Saturday. Both have indefinite durations to them. So unlike the first order from the governor, it doesn't have an end date yet. The first one, of course, ended April 30. The changes in the law at the state, local, and national level are fast and they're fluid. But we're going to have you up to speed and up to the minute today. And I wanted you to know that we're also going to follow up with a checklist that businesses can use to reopen. So it's going to sort of summarize. We should have that done tomorrow or maybe Thursday at the latest. And if anybody wants to email me at paul@donnellygross.com, you can get that checklist, or you can go to the website, donnellygross.com, and we'd be happy to have you look at it there, or feel free to pop me an email and we'll just send you the checklist. And we'll also send you a guide for reopening business, which will be very similar to the presentation you're going to see here today. Okay, so let me get that PowerPoint up and share the screen. there we go. All righty, let me move this. All right, we're good. You don't want to see this though. How do I move that, Joe?
All we can see is your PowerPoint.
It's
Oh, good. You can only see the PowerPoint. That's fantastic. Thanks. Little technological challenge here. Okay. So the Rotary Club is calling this presentation the Business Reboot and COVID-19. And we're going to try to reopen these businesses while keeping employees and customers safe. Now let me get the PowerPoint's not going. Joe, I may need you to, no, there we go. Okay, so the goal is to protect stakeholders, both employees and customers, and meet legal compliance and litigation mitigation. I saw a statistic published a couple days ago that in the United States so far, there have been at least 772 lawsuits filed. We expect an explosion of lawsuits in the area of negligence and employment law in particular. So that's what this presentation will be geared towards as well, so we can reduce risk for businesses as they reopen in the coming months. And we do expect an explosion of lawsuits. We saw that after the Great Recession, and we saw that after the dot-com bubble, particularly in these two areas of law. So the legal framework. We've got the governor's executive orders, Alachua County's emergency orders, and we have guidance from three main federal agencies: the CDC, the Equal Employment Opportunity Commission, and OSHA. The CDC and the OSHA guidelines, as we'll talk more about, are incorporated into the various other orders in many places. Okay, so on May 4, the governor issued his latest executive order. You'll see a hyperlink that you can go and read that order. Generally, it provides that services should continue to follow safety guidelines issued by the CDC and OSHA. And we've got links to those as well for you. And it says that if necessary, employee screening or use of personal protective equipment should continue. The new order allows on-premises consumption of food and beverages for restaurants if they meet the following criteria. They've got to adopt appropriate social distancing of at least 6 feet. They've got to limit indoor seating to 25% of occupancy. They have to do, they're allowed to do outdoor seating if there's social distancing. And the seating, which has to be 6 feet apart, cannot have parties of more than 10. The bar, if there's a bar in the restaurant, those bar counters have to be closed to any seating. The executive order issued Thursday extends the prohibition on consumption of alcoholic beverages in bars, pubs, and nightclubs that make 50% or more of their gross revenue from the sale of alcoholic beverages, and it keeps gyms and fitness centers closed. The order allows in-store retail sales establishments to open up if they operate at no more than 25% occupancy and abide by the guidelines from the CDC and OSHA. He's allowed museums and libraries to open as long as they're under the 25% occupancy level. But public museums and local libraries may operate only if the local government permits it. And they can't have these interactive components like the child areas and whatnot. Those have to be limited. The governor's also opened up elective medical procedures again. Hospital, surgical centers, office surgeries, dentists, orthodontists, endodontists, and other healthcare practitioners are allowed to start working. Those healthcare facilities are only allowed to operate if they've got the capacity to immediately convert to additional facility identified surgical and intensive care beds for treatment of COVID-19 patients in case we get a surge. The facility has to have adequate PPE, personal protective equipment, to do all the medical procedures and respond to COVID-19 treatment needs. The facility also cannot have sought any additional federal, state, or local assistance regarding PPE supplies. In other words, they've got to have they've got to already have their supplies. The facility also cannot have refused to provide support to skilled nursing facilities, assisted living facilities, and other long-term care residential providers. Again, this order is indefinite. It is valid until another order is issued, and this is what the governor is calling step 1. So, we'll see what step 2 brings. The order does not, and there was a lot of confusion about this when the first order came out, it does not preempt local rules where those rules restrict a business, are more restrictive of a business or a building. And we're going to drill in now on the Alachua County emergency order, which applies countywide. It was issued Saturday. We've got a link there for you to go and pull that up. They had a public meeting Friday and then turned it out on Saturday. It was effective May 4. Some of the differences and similarities are that places of public assembly are still closed, but retail may open subject to limitations regarding occupancy based on space, and those limits are different than what and more restrictive than what the governor's order provides. We'll talk more about that in a minute. Of course, essential services and activities are encouraged to remain open. Everybody's got to comply with the social distancing requirements as recommended by the CDC and Surgeon General of Florida. They've got to maintain that 6-foot distance between employees and between customers or members of the public, including standing in lines. They got to make every effort to reduce the on-site workforce by 50% to a 50% capacity. The OSHA guidelines need to be followed. We've got that link for you too, and we're going to summarize some of those. You've got to educate workers of the standards and require the standards to be followed. And you've got to comply with the requirements of any industry association or governing body or licensing authority that may be imposed in your particular field. Restaurants, under the Alachua County order, restaurants and food service facilities may comply with the FDA best practices for retail food stores, restaurants, and food pickup and delivery services during the COVID-19 pandemic. And we've got the link for you there to that as well, if you're involved in a restaurant. Here's a main difference with the governor's order, and it is more restrictive. Essential services and activities and retail are limited to an occupancy of 1 per 500 square feet of covered space. Now that's a change from the prior county order, which was 1 per 1,000 feet and was limited to the essential services and activities and did not permit retail. So the difference here is that a 25, and I kind of have some knowledge of this based on my work for the firefighters associations, but the occupancy levels in buildings, they'll say, for example, this building has an occupancy limit of 100 people. 25% of that would be 25 people. That in a retail establishment is permitted by the governor's order, but that may not be permitted by the Alachua County order because 25% or 25 people in a 100 occupancy max place may be way over the 1 per 500 square feet. So you got to, again, ensure appropriate social distancing. Restaurants, the rule on restaurants in Alachua County, though, is the same as the governor's order. So that's the 25% occupancy. And the Alachua County order makes clear that outdoor seating does not count against the indoor occupancy. Let's see, occupancy limits do not. Yeah, and they don't, by the way, that doesn't count staff. So occupancy limits don't count staff as long as you're doing social distancing. A major difference also in the Alachua County order from the governor's order is that people working in or visiting grocery stores, restaurants, pharmacies, construction sites, public transportation, Uber, and locations where social distancing measures are not possible must wear facial coverings. These face coverings must be CDC compliant. They've got to snugly cover the face. Therefore, bandanas are really not the ideal and don't really meet that criteria. However, the CDC does say that where you have nothing else, you can use a bandana or scarf or other face covering. You do not have to wear face masks while eating or drinking. Now, again, the idea with the face mask is that it prevents transmission by you to someone else. Is the primary reason for wearing these face masks. And the idea is you need those face masks where you do not have social distancing. Let's see. By the way, violation of the order is a second-degree misdemeanor. So beware of that. So law enforcement is charged with enforcement of these rules. All right, so now let's drill in on the CDC, EEOC, and OSHA. The CDC has issued an interim guidance for businesses and employers to plan and respond to the coronavirus disease. That is a very user-friendly document. You can click on the link there to get to it once you get a copy of this PowerPoint. OSHA has also issued guidance on preparing workplaces for COVID. OSHA breaks down the guidance into 4 levels. 1 is low risk, next is medium, next is high, and the third is very high. Bottom line is very high would be people who are involved in actually treating COVID-19 patients, and very low, obviously, is the complete other end of the spectrum. The EEOC, which is the federal agency, the Equal Employment Opportunity Commission is the federal agency charged with issuing regulations and even filing lawsuits and investigating claims by employees or groups of employees regarding discrimination and retaliation under various federal laws. They have issued their own guidance where these issues overlap with the Americans with Disabilities Act, a federal law called the Rehabilitation Act, which was predated the Americans with Disabilities Act and applied basically to federal contracts and the federal government. And the EEOC has also issued a pandemic preparedness in the workplace bulletin as well, which we've got the link for you there. The essence of the guidance from all of these 3 federal agencies, again, the CDC and OSHA are incorporated by reference into the governor's order and the Alachua County order, is regarding employees, that the idea is to monitor and screen employees and develop policies and procedures so you can identify and isolate sick employees. And the goal is also to protect employees. We need to implement basic infection prevention measures. Customers also are designed to be protected, particularly by implementing prevention measures. So let's focus on the CDC. Obviously, the goal of the CDC is to reduce transmission among employees. It suggests that you actively encourage employees who are sick to stay home, that you identify places where workers can be exposed at work, that you separate sick employees, and that you educate employees about how to reduce the spread of COVID. Taking these reasonable measures are going to go a long way in protecting the business from potential claims, which we expect to be opening up here in the next few months. The next federal agency, the EEOC, they made it clear, well, first of all, the Americans with Disabilities Act, and we, by the way, have a Florida statute that provides exactly the same as the Americans with Disabilities Act, and creates a state law cause of action or lawsuit that people can file as well. The Americans with Disabilities Act permits employers to make disability-related inquiries, and conduct medical exams if they're job-related and consistent with business necessity. Now, that's the rule. However, the EEOC's guidance says that an employer does not engage in lawful discrimination when screening and excluding employees from the workplace based on COVID. Employers are allowed to ask employees if they're experiencing symptoms of the pandemic, including fever, chills, cough, shortness of breath, or sore throat, or the other symptoms. But under the Americans with Disabilities Act, the business must maintain all information about the employee's illness as a confidential medical record to be compliant with the Americans with Disabilities Act. The EEOC made clear that you're allowed to measure body temperature for employees. You can send employees home who have the COVID-19 or symptoms that are associated with it. The business can require a doctor's note certifying the person is fit for duty. And the business can administer COVID-19 tests prior to employees entering the workplace. But the COVID-19 test is only supposed to be used if the test is accurate and reliable. And there are some tests that are coming on that are becoming more reliable that the FDA has allowed to be used. Let's look also at the CDC again. The CDC recommends having a workplace coordinator who'd be responsible for the COVID-19 issues. They recommend flexible sick leave and supportive policies and practices. They ask you to determine how you will operate if absenteeism spikes, and the CDC asks that you establish policies or practices for social distancing and that you disseminate those and make employees aware of them and have them follow those. Many obviously workplaces and industries are different. Some will need to look at their building ventilation systems. Certainly the business wants to support respiratory etiquette. You don't want to sneeze and cough on people, dispose of Kleenexes and tissues, have hand hygiene, whether it's washing with soap, saying the ABCs twice when you wash with soap, have hand sanitizer, perform routine environmental cleaning and disinfection of where places primarily are touched, make sure people are disinfecting coming in and out of the facility, advise employees before traveling to take preparations, and take care when attending meetings and gatherings. By the way, hand sanitizer is really hard to find now, but there are some distilleries that have converted their operations, and I do know that the St. Augustine distillery over in St. Augustine is making hand sanitizing alcohol available. I think there may be a waiting list, but you may want to look into getting in line on that. All right, back to some of the EEOC on protecting employees. The requirement, if an employer institutes a requirement, as it should, of regular hand washing, etiquette as to coughing and sneezing, and proper throwing away of tissues and disposing of them, this does not implicate the Americans with Disabilities Act. So you're free to do that under the ADA. And you're free to require employees wear personal protective equipment, face masks, particularly where the social distancing isn't possible in the facility. Some more on OSHA. Personal protective equipment standards are specified in the OSHA guidance. We'll have a link for that for you too. That means gloves, eye protection, and respiratory protection, depending on the level of your risk, whether you satisfy the low, medium, high, or very high level risk category. I should mention what the general duty is under OSHA for employers. And it's a basic rule, it's at the bottom of this slide. Employers are required to furnish each worker with employment and a place of employment free from recognized hazards that are causing or are likely to cause death or serious physical harm. So employers have an affirmative duty to take steps to make the workplaces as safe as possible. And OSHA reiterates some of the things we've seen under the CDC guidance for developing policies and procedures to identify and isolate sick people, to actually do that, identify and isolate potentially infectious folks, to educate the employees about self-monitoring for signs and symptoms of COVID. By the way, OSHA, if you go to their website, they've got a very user-friendly website, and they've got a poster that you can post in the workplace that helps with that kind of information and notice to employees and customers. Your policy or procedure regarding this COVID situation should include notifying the employer of sick people, or if employees see other people experiencing symptoms. The OSHA requirement is to provide face masks where appropriate, isolate people who have confirmed cases, restrict the number of personnel entering into any isolation areas if you're the type of risk level that needs that, and protect workers in close contact. They require good hygiene and infection control practices, frequent and thorough hand washing, alcohol-based rubs with at least 60% alcohol, encouraging workers to stay home if they're sick, and encourage respiratory etiquette, covering the mouth for coughs, not with the hands, but with something else like the elbow, and from sneezes and things like that. Now, by the way, there is the federal law that was enacted a little more than a month ago does provide for certain paid sick leave and extended family and medical leave under certain types of COVID and COVID-related situations that we can talk about if we have time or if folks are interested. The OSHA encourages using flexible work sites like telecommuting, which most of us are doing, and flexible hours, which I think many of us are doing. Obviously, increasing physical distance, discouraging workers from using anybody else's phone if they're at the office, using only their own desks, equipment and tools, sanitizing those afterwards, common conference room areas being sanitized, regular housekeeping of the facility, which the housekeeping should include sanitizing high traffic and touched areas. Let me see. And they remind you to follow manufacturer's instructions on sanitation supplies. All right, so back to a little bit to the EEOC now. What if a disabled employee does not want to return to the office? Well, the EEOC and the Americans with Disabilities Act requires what they call an interactive process, which simply means asking and engaging in dialogue with the employee. You need to ask how the disability creates the limitation, how the requested accommodation that they're asking for will effectively address the limitation, and you need to look at whether another form of accommodation could effectively address the issue. And whether the accommodation that the employee is proposing or that the employer is considering, and it's up to the employer to decide in the end what that accommodation is, if appropriate, to use the accommodation. The accommodation has to allow the employee to continue performing the essential functions of the job. So you can probably imagine we receive an enormous number of questions from our business clients and others about employers about these laws that have been coming on, these regulations that have been constantly interpreted and reinterpreted. One is, particularly from the essential businesses, the ones that were allowed to operate, for example, in the construction industry. What happens if somebody doesn't want to come to work because they fear that they might be infected or get infected with COVID? Well, if they're not disabled, and they're not doing it because they've actually got the disease or some other disease that could be exacerbated by COVID, there's no accommodation that has to be required for them. There's work for them, and they can be let go if necessary for not coming to work. So that's kind of an interesting twist. So what about hiring new employees? Well, the EEOC makes clear that you can screen for COVID, you can take their temperature, you can delay the start date if the employee is symptomatic, and if it's somebody who you've made an offer to hire, who doesn't already work for you, You literally can rescind the job offer if the employee, the prospective employee, the potential new hire who you've made an offer to, is symptomatic. So kind of another twist on this, what if I don't want to return to the office? Well, we talked about if you have a disability, such as if you have an immune compromised disease or disorder, that might rise to the level of a disability under the Americans with Disabilities Act. And that can be a sticky wicket too, whether a particular illness actually rises to the level of a disability under that law. But assuming it does, the employee should request a reasonable accommodation and ask for the interactive communication process to see if that can work. Now, if the employee's not disabled but still worried, the employee might want to consider suggesting solutions such as remote work or alternative hours. Now, what about customers? One of the best things you can obviously do I'll mention it, to protect customers is to screen, monitor, and protect your employees and have a sanitized and regularly sanitized workplace. But you want to also make sure you can provide running warm water and soap. This is particularly important if you do not have adequate hand sanitizer. If you have hand sanitizer, please provide that. Provide tissues and trash receptacles that can be appropriately, safely cleaned out at the end of the day, and then the people who are doing that sanitize themselves. Make room for social distancing, reduce exposure of employees, and follow the state and local orders and federal guidance. Those are the things you really can do to help your customers. So legal compliance and legal mitigation. This slide is helpful because it shows you all the different laws that provide guidance and rules. And most of these also provide the ability of a lawsuit to be filed against an employer. So over on the left side of the slide, we list the federal statutes. The OSHA. There are industry-specific statutes and regulations that we did not list here. The Americans with Disabilities Act, the FFCRA is the Families First Coronavirus Response Act, which was enacted about 5 or 6 weeks ago or so, that provides for paid sick leave under certain circumstances, and Extended Family and Medical Leave Act, which requires 2/3 of pay for certain situations, and I can drill into that if anybody would like. Of course, the CARES Act, the Family and Medical Leave Act. The FLSA is the Federal Fair Labor Standards Act. That's the law that was enacted in the Great Depression regarding overtime, minimum wage, and child labor. That law is very much implemented, particularly in the overtime context and time and record keeping context, particularly with people not working in brick and mortar, but working remotely. Timekeeping is critical for businesses to limit their potential risk of a lawsuit. We've seen an explosion of these lawsuits. Florida is the home of approximately, last statistic I saw, 30% of all federal lawsuits filed under the FLSA for overtime, minimum wage. 30% of all lawsuits in the United States roughly are filed in the Florida federal courts. The National Labor Relations Act is in play. That's the labor law regarding labor unions and employees engaging in protected concerted activity, even if there's not a labor union. That applies to many private businesses, most private businesses, but not all. There are some small business exceptions. Title VII, that's a comprehensive federal law that covers race discrimination, gender discrimination, pregnancy, disability, various others fall under that ambit. And the WARN Act involving mass layoffs. That requires if there's a layoff of, if you're an employer of certain size, there's 100 or more employees. There's, if you're gonna lay off 50 or more, there's requirements of advance notice for that layoff. Under Florida law, many of the laws I just mentioned under federal law are also provided under Florida law, and they're found in Florida statutes, but I won't repeat them. I'll tell you what's in addition. The Florida Workers' Compensation Act is certainly in play here. There'll be claims, and there have been claims of COVID exposure in the workplace that are dealt with under the Workers' Compensation. There's the Florida's Whistleblower Act, which we're going to see claims under where employees are complaining about a violation of law, rule, or regulation. There are very, very specific requirements that have to be followed in that law, and I can certainly answer questions if anybody has them about that. Of course, we've got the executive orders of the governor. There is the common law duty of care. So negligence claims will be potential here. And then again, in Florida, we also have some industry-specific requirements. Again, local law, the Alachua County order, and the cities are allowed to issue orders as well, though Alachua County is comprehensive and applies countywide. Under OSHA, I want to mention that the new guidance they've issued is not a standard or regulation. It creates no legal obligations. The business is supposed to comply with existing safety standards and industry-specific standards. I'm going to move along so we can get to questions. I won't talk about the duty of care, and at the end of this PowerPoint, you will see that we have more links for you to go to. So I'll stop sharing the screen and hope I didn't run too long, and I will remain as long as necessary to answer any questions.
All right, well, thank you so much, Paul. Thank you for speaking to our group today. We really appreciate your time and your expertise. I have a number of questions. I don't know if we'll be able to fit them all in by 1, but typically what we do is stop a little before 1. Jason may have something to add, Richard will, and then for the folks that want to stay, if you're willing and able to stay, then we'll continue with the questions from there. Sound reasonable?
Sure thing.
All right. Let's see. One of the justifications for the governor's original order was that it was limited in duration to 60 days unless it was renewed by him. Doesn't an order without a termination date weaken the argument that it's narrowly tailored to the extent necessary to fulfill a compelling government interest?
I don't think that's a possible, I think that is a losing argument by whoever wants to raise that. We're in an unprecedented crisis in terms of the healthcare system and the economy. And I don't think there's a court in the world that would find that a reasoned, measured approach to this situation isn't a necessity for the government to act.
All right, thank you. How does the ban on public assembly relate to churches and other houses of worship?
Okay, that was a unique thing. The governor's first order, and again, of course, the second order allows places of public worship. So religious facilities and whatnot have been allowed as long as they keep the 25% occupancy and the social distancing. So they have been allowed from day one in the state of Florida and continue to be.
How about summer camps and other sorts of gathering places like that?
All closed down. And they will, you know, what we'll need to see is whether any of that is going to open up, you know, in the second phase. And I think a lot's going to depend on the trajectory of the virus and the cure or the treatments that are developed. But there are some circumstances where childcare facilities are allowed to open under some circumstances. Again, using the social distancing and all that. Primarily, if I remember correctly, it's primarily, and if anybody wants the specific answer, I'll get it for them 100%. But my memory on that is that it was the child care for healthcare workers and first responders.
All right, thank you. If an employer asks employees if they've traveled to highly affected areas like South Florida, or if they've attended gatherings of more than 10 people and the employee says yes, can the employer ban them from coming to work?
Yes.
Is there a length of time? Can they do that for 2 weeks or?
Well, there's no legal requirement on the length of time. The guidance from the CDC is 14 days from an exposure, right? If you have a potential, you know, if you've been in a situation where you may have been exposed, you travel to a country you know, like let's say you went to Spain and came back, it's totally permissible to, and they're asking you to self-isolate for, quarantine is probably not the right word, but self-isolate for 14 days. And so, yeah, the employer has the right to do that. Now, the one area where there may be a little more, what we might need to focus on is if the employee has a contract to be employed for a specified duration of time. Otherwise, employees in Florida are employees at will. They can quit, or they can be hired, they can be fired for no reason, any reason, even a bad reason, just not an illegal reason. And our slideshow was about a lot, you know, the laws that say these are illegal reasons, this is why you can't let somebody go. But if they're an employee at will, the employer has generally free reign, subject only to those laws.
Okay, how about the other side of that? An employee that's at high risk, say an older employee with heart problems or something like that, are they required to go to work? If they're a teacher, for example?
Yeah, now that may be different. That's where the Americans with Disabilities Act comes in. Because if the person really has a bona fide disability, okay? Like, for example, if they're immunocompromised, under the circumstances we face now with this virus, that person is probably, according to the EEOC, entitled to reasonable accommodation. If the reasonable accommodation can allow them, if it's reasonable, if it's doable financially and otherwise, and if it can allow the person to perform the essential functions of their job.
Okay, so I got a series of questions here that relate to lawsuits. So I'm going to read you more than one, and then if you don't mind speaking on that.
Okay.
There's so much risk of lawsuits. Is there any chance that federal legislation would protect employers? Why would it stop with COVID and not extend to chickenpox, seasonal flu, and other of those sorts of diseases? And then that led into, is it time to discuss tort reform and on from there? What are your thoughts on that, Paul?
Yeah, there's a effort in Washington to provide some tort reform regarding negligence lawsuits, as I understand it. I would not predict that Congress will change the ability to sue employers under that whole panoply of laws that we saw on that slide and that we kind of talked about, or that I talked about. For example, when Congress enacted and the president signed into law the Families First Coronavirus Response Act, which required employers to pay up to 2 weeks of paid sick leave if they had a qualifying COVID-related situation, or provide 2/3 of pay for up to what amounts to 12 weeks total of certain qualifying conditions for the Family and Medical Leave Act for caring for others, basically. Congress did not exempt businesses. And traditionally, though the Department of Labor is charged by Congress with enforcing those laws and has the right to investigate alleged violations, it did not exempt businesses from those claims. And we're going to see them. They're going to happen. And I predict they're going to happen because primarily what we have seen time and again with these economic downturns is that, quite frankly, people are looking for money wherever they can get it. And so we're going to see these lawsuits.
So we have time for one more question before we wrap up our meeting, and then we'll do more questions after that if you're able to stay.
Sure.
The last question is, how about employees that refuse to come back to work because they're drawing unemployment, state, federal, whatever they're getting, and that's more lucrative for them than working?
Okay, so if the employee, if you've had to lay somebody off and you don't need to lay them off anymore and you can bring them back and you make them an offer of reinstatement, that may negate their ability to receive that unemployment compensation. It would be, in other words, they would basically be voluntarily quitting. They'd be leaving the job without good cause attributable to the employer. So people get unemployment for two reasons. One, that they were terminated for willful misconduct, okay, which is a very difficult standard because it's a benefit to help people get along for a little bit. You can't fire, it's hard to prove willful misconduct, but they can be denied unemployment compensation if they voluntarily left employment without good cause attributable to the employer. That's what that situation would be. So if you make an unconditional offer of reinstatement to them, they can, unemployment could be, or reemployment is what it's called now, could be notified, and that would probably stop that unemployment benefit.
All right. Thank you, Paul. We're out of time for our meeting. Thank you so much for speaking to us today. I really appreciate your time and your expertise. We are going to make a donation in your name to have 100 children inoculated from the polio virus.
Oh,
as a thank you to you. Yes, sir.
Wow. Thank you. Thank you so much.
Thank you so much, Paul. Richard, would you tell us what we can expect for next week's meeting?
Yeah, and I'm going to make this super short because we have a lot of questions remaining, and those who want to be able to get them in, we want Paul to be able to answer them. So next week, we originally had scheduled a husband and wife vaccine development team. However, they had to cancel as of yesterday because they're literally in the process of filing for their vaccine with the federal government. So we're working right now on getting another infectious disease doc that will be able to talk to us next week about what we're going to be looking for as we reopen the economy and move forward. So that should be a really exciting meeting. If you would invite everybody that you can think of to attend our meetings. This is a great way for us to spread the word about what Rotary does in the world. So please do that. Wes wanted me to remind you one more time that if you do a makeup on the YouTube channels, to please email us at info@rotarygainesville.org so that he can get it into the makeup. And that's it. I'm going to turn it back over to Chad and Paul to continue the questions. Thanks, everybody.
Thank you so much, Richard. We are adjourned for today. If you are able to stay, I think Paul can stay and we'll do some more questions. If not, have a great week. We'll see you next week. Paul, the next question on here, what sectors of society do you see being the most litigious? Medical, government, lawyers, who's going to get sued?
I would imagine we will see places that were not deemed essential, which were required to really close and shut down operations or dramatically reduce them. And I think that's an area where we're going to see the most. The second area, and maybe this would be the first area, will be people who are telecommuting and claims regarding amount of, pay and overtime and that kind of thing, timekeeping kind of claims. And I think it's going to be across industries. The hardest hit, I think, with litigation will probably be those that had to close.
If a business has a published policy that meets the intent of CDC, state, county guidelines, it makes it clear to the employees to report or bring to management any concerns related to inadequacy of the policy. Do you think that would represent a reasonable employer effort and relieve or reduce the employer liability?
No doubt, no doubt. Not the best thing you could do to protect yourself. And by the way, we've got, we can send them to you if anybody, wants, just let me know. I mean, there's different policies. You don't have to rewrite these things from scratch, and you can look at other policies. For example, there's the Society of Human Resource Managers issued a sample policy on the emergency paid sick leave and the Extended Family Medical Leave Act, and they even have a form that we really like. I mean, I think we've done very little editing to it, and so a lot of these policies are readily available. Again, the links that we have for the CDC, very, very user-friendly guides. There's also the Department of Labor. If you go to their website, they have this notice that you can post that talks about the sick leave, because you're supposed to post this notice about the emergency sick leave and Extended Family Medical Leave Act stuff. So a lot of that stuff is really just, in the box. You just open it up and use it.
I think that's it as far as questions. I don't see any more. Do we have any more questions?
I'm happy to stay around if anybody wants to chat.
I'm also going to mention that in the follow-up to this, I'll be sending around the several of the links that Paul sent. I'll also be sending around the slide deck that he used that has a number of hyperlinks in it. I think you referenced an OSHA poster. I'll be sure that it includes the link for the OSHA poster.
Oh, that's great. And remember, we're going to send out a checklist, which I think will be very helpful. Instead of a bunch of, we'll have that guide too that's based on this PowerPoint, but I think a checklist is going to be very helpful that people can go check, don't need to do that, don't need to do that, yeah, I need to do that, check. I think it's going to be really neat. We'll get that out, and I'll get you one, Richard, if you want to send it to the members.
Yeah, thanks. You know, as the original question about the lawsuits and federal protection for businesses was from me, because I was looking at your one slide that lists on the left side all the federal laws and regulations that everybody has to abide by, and on the right side all the state, and I'm thinking there's probably no chance that any business out there will not unknowingly violate one of those rules somewhere, and as soon as they do, every business is open to be sued. So
well, that's right. But let me just get on my soapbox for 1 second. Even if you take all these steps, there's going to be these suits. And I would submit to you that some of these suits will not be valid. They will simply be claims made. I'm telling you, we've seen this before. People do get desperate, and people are going to look to shake money out of whatever tree they can. And again, we've seen in the negligence area, we've seen all kinds of suits already getting filed.
All right. Paul, thank you so much for generously taking your time to talk with us. Your advice and willingness to answer questions is very valuable, and we all appreciate it very much.
Well, I'm grateful for you having me here.
Okay. Thank you.
Thanks.
Bye, everyone.